Phones go back on, we'll start. Here we go. We have microphones, so we're going to begin. If people could please take their seats. Thank you. My name is Cindy Arnson. I'm the director of the Latin American program here, and I'd like to join my colleagues Rob Litvak and Philippa Strum in welcoming you to this session on a very important topic of debate. I'd also like to continue with Flip's request for people to turn off their cell phones with a request to turn off the transmitters on your Blackberries, which is the interference that you're hearing through the microphones. I'm going to give each of the three panelists in this next session, Amrit Singh, Tom Parker, and Juan Mendez, exactly 15 minutes. And I guess using the lexicon of the morning, I will be between a severe and brutal timekeeper, at least very strict in that regard, because I think we're fortunate that William Taft and David Rivkin have agreed to stay to be able to comment on the presentations that will be made by our three panelists in this second session before they have to leave. So in order to give them time to respond and yet meet their other obligations, we will maintain the 15-minute time limit very strictly. We'll start with Amrit Singh, who is a staff attorney for the American Civil Liberties Union.
Good morning. Since I have very little time, I'm going to launch right into government documents related to the torture of individuals held in U.S. custody in Iraq, Afghanistan, and Guantanamo Bay. Just to give you a very quick background on these documents, they relate to a Freedom of Information Act request that the ACLU filed in October of 2003. We received close to nothing by way of response from the federal agencies with which we filed this request, and for about 6 or 7 months. And in April of 2004, the Abu Ghraib photographs became public. And the FOIA request, I'm going to refer to Freedom of Information Act as FOIA. The FOIA request was seeking documents related to the treatment of individuals held in U.S. custody abroad and documents relating to the rendition of individuals by the United States to countries known to employ torture. We still have not received anything on rendition, but we have received a large number of documents, mostly from the Defense Department, that shed some light on what actually was going on. I would just add that this litigation is currently pending in federal court in the Southern District of New York, but these are the documents that we have so far received. We hope to get more. That the remaining documents that are being withheld are also of critical significance for shedding light on what the policies of the administration were with respect to interrogation techniques and detainee treatment generally. So let me start. Most of the documents that I'm going to show you are Freedom of Information Act documents. They were derived. The DOD was forced to turn them over after we filed a lawsuit. It was after a federal judge said to DOD that they had to respond that we slowly started getting documents more than a year after we filed our FOIA request. So here we go. So one thing, I'm going to tell a story basically, and you have to understand that there are lots of different sources of information. One recent source of information is not a FOIA source, but it was a DOD report that was just released about last month. It's a DOD Inspector General report, which talks about the evolution of interrogation techniques for use in Guantanamo Bay. And the report talks about how in the summer of 2002, a review was done of interrogation methods being applied in Guantanamo, and it was found that they were not effective at obtaining intelligence. And at that point, I believe it's the Joint Special Operations Command worked with the Joint Personnel Recovery Agency, which is the latter is essentially involved in administering and monitoring the use of what is known as Seer Techniques. Now, Seer Techniques I think were sort of alluded to in the last panel discussion by Mr. Rivkin. Seer Techniques, the acronym Seer stands for Survival, Evasion, Resistance, Escape. And these are techniques that were essentially developed by the Defense Department as a defensive purpose. They were essentially developed so that U.S. soldiers who were caught by enemy forces could withstand interrogation, aggressive interrogation methods. The whole purpose of SEER was to protect intelligence that the United States didn't want turned over, was to help U.S. forces withstand interrogation. It was never intended to be used offensively on enemy captives. So by the summer of 2002, JIPRA, the Joint Personnel Recovery Agency, was developing SEER techniques with a view to using them in an offensive manner. There was, and then the JIPRA started training interrogators in Guantanamo in these SEER techniques. And just to give you a sense of what SEER essentially involves harsh interrogation techniques. It's still unclear what exactly they include because all of this information is still being withheld. But it certainly includes, we think, stress positions, bombarding detainees with loud noise, and we believe that there are extreme versions of SEER that relate to close confinement or the use of and also the use of waterboarding. Although again, I will add a caveat here: I am not sure of any of this. I haven't seen a document to that effect, but certainly there's some indication that SEER can go far on, towards what Mr. Rivkin would call torture. So just to give you a sense of what is the first document we have relating to interrogation techniques is this December 2002 memorandum from Donald Rumsfeld. It was a memorandum from Haynes to Rumsfeld. Recommending the adoption of certain interrogation techniques. This, again, this was vetted from among the highest level officials at the Pentagon. It was vetted with Doug Feith, with General Myers, and Haynes, of course, himself. Just to give you a sense of what the recommended techniques were. And this is why I think that this was sort of related to the SEER program. There were a set of techniques called Category 3 techniques that related to, and the memo itself says, the following techniques and other aversive techniques, such as those used in U.S. military interrogation resistance training or by other U.S. government agencies, may be utilized. And then it goes on to say, the use of scenarios designed to convince the detainee that death or severely painful consequences are imminent for him and or his family, exposure to cold weather or water, and then finally use of a wet towel and dripping water to induce the misperception of suffocation, and the last one, use of mild, non-injurious physical contact, such as grabbing, poking in the chest with the finger, and light pushing. Now, Rumsfeld did not approve any of these latter techniques except for the use of mild, non-injurious physical contact. But Rumsfeld left open the possibility of interrogation techniques being approved by him on a case-to-case basis. So not everything is necessarily represented in this memorandum. I would add that the administration has always taken the position and consistently taken the position that what happened at Abu Ghraib had nothing to do with policies that were adopted by the Defense Department or the administration. Well, we don't have anything by way of smoking gun evidence, but certainly the evidence, the circumstantial evidence that we have obtained through the use of our FOIA documents suggests that the removal of clothing that was routinely depicted in the Abu Ghraib photographs was certainly a technique that was authorized by Secretary Rumsfeld for use in Guantanamo. Let me just pull it up. Here it is, number 10, removal of clothing. And stress position, the photographs that showed individuals shackled to railings, shackled to doors, shackled to their cell walls. Well, that's a form of stress position. So I think, at the very outset, I'm not sure whether I'm going to be able to get through all of these documents, but I think the most important thing about these documents is that the torture debate must be informed by what is going on the ground. And while all the facts are not presently available to us, we know that what was authorized for use at Guantanamo certainly spread to Iraq and Afghanistan. And it spread to Iraq and Afghanistan in forms that were perhaps much worse than what was originally intended. Again, these techniques were approved for use in Guantanamo over the consistent objections of the FBI. Here's an FBI document talking about saying, I am forwarding this electronic communication up the chain of command. The FBI has requested this information be documented to protect the FBI. The military liaison detainee unit has had a long-standing and documented position against some of DOD's interrogation practices. And then it goes on. And the last one, these tactics have produced no intelligence of a threat neutralizing nature to date. And CITF, which is the Criminal Investigations Task Force, which is not the FBI, it's the Army's CITF. The CITF believes that these techniques have destroyed any chance of prosecuting this detainee. And then the final sentence. If this detainee is ever released or history made public in any way, DOD interrogators will not be held accountable because these torture techniques were done by the FBI interrogators. The FBI will be left holding the bag before the public. Now, the FBI's motives were, it seems, to protect itself, but nonetheless, we have numerous other documents that show that the FBI and the Army's own Criminal Investigations Task Force began objecting to harsh interrogation techniques applied in Guantanamo from late 2002 onwards up into at least to 2003. And as for the claim that, seemingly innocuous interrogation techniques like stress positions aren't really torture, well, I would urge all of you to watch that film, Road to Guantanamo, for one thing, because you'll know that these so-called innocuous techniques are in fact not so innocuous when you see how they're applied, particularly when they're applied in tandem. One eyewitness account from an FBI agent says of what he saw at Guantanamo. On a couple of occasions, I entered interview rooms to find a detainee chained hand and foot in a fetal position to the floor with no chair, food, or water. Most times they had urinated or defecated on themselves, had been left there for 18 to 24 hours. On one occasion, the air conditioning had been turned down so far that the temperature was so cold in the room that the barefooted detainee was shaking with cold. I'm going to just blip over to the last line. The detainee was almost unconscious on the floor with a pile of hair next to him. He had apparently literally been pulling his own hair out throughout the night. So we don't know exactly what interrogation techniques this reflects, but we can conjecture that stress positions were involved because the person was constrained in this particular position, and in particular environmental manipulation, which involves subjecting the prisoner to extremes of temperature, may have also been involved. Again, another document entitled Suspected Mistreatment of Detainees, documenting the use of dogs in September or October of 2002 that was witnessed specifically by FBI agents. Again, I think, quite apart from whether or not this amounts to torture, which I think is a somewhat irrelevant question, I think that it's really especially disturbing that the administration has consistently taken the position that the allegations of prisoner abuse were basically concocted, were lies, were, I believe, Secretary Rumsfeld referred to these as hyperventilation. These are eyewitness accounts of FBI agents which cannot be dismissed quite as easily as the nameless people who are locked up for years without any access to the public of any kind to be able to tell their story. Very quickly, here's an FBI document that talks about the objection the FBI made to Seer Techniques. In late 2002 and continuing into mid-2003, the Behavioral Analysis Unit raised concerns of interrogation tactics. As a result, an electronic communication dated May 30th, 2003 was generated summarizing the FBI's continued objections to the use of Seer Techniques. And it says, it should be noted that FBI concerns and objections were documented and presented to Major General Jeffrey Miller, that was the commander at Guantanamo. Okay, I have very little time, but we have worse things that happen in Iraq and Afghanistan. At some point, wish lists of interrogation techniques were sought from interrogators. They responded saying close quarter confinement would be a good idea. They also recommended phone book strikes, low voltage electrocution, closed fist strikes, muscle fatigue inducement. This is an order from Lieutenant General Sanchez adopting many of the same techniques that Rumsfeld had authorized in December of 2002, including the use of dogs to intimidate detainees and the use of stress positions. And this is the memorandum that I think is particularly important to get across, particularly in response to what Mr. Rifkin was talking about. This is a response, this is a defense that Chief Warrant Officer Welshofer made when it appeared that he was going to be reprimanded for the murder of General Mahoush, who was a detainee held in U.S. custody in Iraq. He defends the use of placing Mahoush in a sleeping bag. Mahoush died of asphyxiation. And Chief Warrant Officer Officer Welshofer says, and I'm looking at the last paragraph here. In my attempt to gather intelligence to protect the lives of soldiers, I used stress positions that included kneeling, standing, placing the detainee in a close confinement stress position that I considered acceptable. This stress position previously added intelligence collection that targeted anti-coalition forces. The sleeping bag techniques is a stress position I considered authorized by CJTF 7 in their memo. And then he cites to the Sanchez memo that I just showed you. Okay. And then goes on to talk about in Seer, this position is called close confinement and can be very objective. Just to show you that torture did happen, and there are a large number of government autopsy reports that torture happened. Here's one of them. The Army itself is labeling this death of a detainee in Iraq as a homicide. The cause of death is blunt force injuries complicated by compromised respiration. This person was caught by Navy SEAL Team 7, resisted apprehension, and there's yet another autopsy report. Here again, cause of death, blunt force injuries and asphyxia, manner of death, homicide. According to the investigative report provided by U.S. Army CID, the decedent was shackled to the top of a door frame with a gag in his mouth at the time he lost consciousness and became pulseless. There are still other documents relating to such deaths in Bagram. Thank you.
Thank you. Amrit, I'm sorry for having to rush you through that. If I'm not mistaken, the documents are available on the ACLU website.
That's
for
correct.
Those who would like to consult them further. I'm going to go a little bit out of the order and call next on Juan Mendez, who is a long-time personal friend and currently is president of the International Center for Transitional Justice in New York.
Thank you, Cindy, and thanks for the invitation to speak on this important subject. I'm going to address it from my very personal perspective of having been a torture victim myself, thankfully a long, long time ago. But my experience in Argentina in the 70s then led to all these following years in a career in human rights, and particularly campaigning against torture in many parts of the world, not only in Latin America. But the question is whether exceptional circumstances allow for permissible derogations of otherwise well-recognized standards. And I'm going to address that from the perspective of a practitioner of international human rights law. I have to say that international human rights law, particularly treaty law, I think is relevant to the conduct of the United States government. I know that many in Washington don't believe that international law even applies to the United States. And in the earlier panel, the discussion was more centered on U.S. constitutional law, so I'm not going to deal with that. But I do hasten to add that, in my view at least, the results, the outcomes are the same. I mean, both in U.S. domestic law, particularly constitutional law, and international human rights law, the result is the same. Torture is absolutely prohibited, and there may be gray areas as to what one considers cruel, inhuman, and degrading treatment that is also prohibited and what is not, but the prohibition is the same either way. And in this sense, it's important to have honest definitions about what we mean, because it's not enough, I think, to say we don't practice torture, but then it all depends on what you consider, how you define it, and that's where I think the administration has been less than candid with the American public, and has been subject to at least doubts about whether some of the things that have been just shown by the previous speaker are part of policy or are not. In this sense, I think international law does allow states to derogate from some from some very substantive provisions in times of war or in times of emergency. But here again, war and emergency, as was said in the previous panel very accurately, are terms of art. We just cannot define them and use them rhetorically. If we use the term war on terrorism the same way we use it as war on poverty, then we are straying from the internationally accepted definition of war. And in that sense, the question of whether international human rights law does apply or not, I think is relevant to what we're talking about, because there's no question that for people captured in combat anywhere in the world, the lex specialis would dictate that the Geneva Conventions apply as they apply or not to, and whatever provisions of the Geneva Conventions apply depending on the circumstance and on the individual. But when somebody is arrested in Bosnia, for example, after the Bosnian government has released him and is taken to Guantanamo, I think it's a little bit of a stretch to consider that person an unlawful combatant, since that person was never caught in the field of battle. My sense is that the war on terror, if we understand it rhetorically, includes actions and measures to which the Geneva Conventions apply, especially all combat-related, and then it includes law enforcement activities to which international human rights law standards apply. And it's not very complicated to try to apply them both and as the circumstances dictate in each case. I think there was a question in the earlier panel about derogation standards and why the United States never announced to other treaty signatories emergency measures after 9/11. That's an important question, but I think more important than whether to do the bureaucratic announcement is whether in announcing suspensions of certain rights, the United States wanted to be bound by the limitations and the standards that apply to those situations in which states are allowed to derogate. And this particularly all human rights standards, including those to which the United States is a party, say very clearly that in an emergency that threatens the life of the nation, it is permissible to derogate from a variety of standards, but one that is completely impermissible to derogate from is the use of torture under any and all circumstances. And I would add, it's impermissible to derogate from the guarantees in the domestic jurisdiction that are there to prevent and to control the possible incidences of those rights that cannot be derogated from, including torture. And that's why I think, again, earlier today we heard a very interesting discussion about whether habeas corpus should or should not apply. As a matter of international law, I think the answer is very clear, that there has to be legal recourse to independent courts of the nation for anybody who is captured and held under these conditions. Now, the standards may be different. It doesn't mean that everybody will go free. It does mean, however, that the administration has to have an independent, impartial, adjudicatory body that decides fundamental questions, like whether someone is a lawful or an unlawful enemy combatant. I'm not saying anything particularly radical here, because even the military courts set up by this administration just this week have said exactly that. I'm proud to say that we at the Inter-American Commission on Human Rights, in 2002, I was its chair, we came to the very same conclusion in a little-known exercise that we conducted on precautionary measures that precisely the ACLU and other organizations had asked us to do, in which 2 years before the Supreme Court said the same thing, we also told the administration that under its obligations under international human rights law, it was obliged to give each person detained in Guantanamo a hearing by an independent adjudicator to determine the conditions and the laws that would apply to each person. It also takes me to the question of terminology. Of course, has to do with the severity requirement for when something is considered torture. And I completely agree with what was said this morning about the ambiguity and the cultural and contextual aspects of when something is severe enough to become torture. But it still is not that hard to determine that certain things just shock the conscience of anybody. Certain types of actions shock the conscience of anybody under any culture, and we need to be able to be sensitive to not crossing that line. Which brings me also to another terminological matter. I mean, we talked this morning about renditions, but we neglected to say that the administration talks about extraordinary renditions, not just renditions. If it were a matter of usual collaboration between law enforcement bodies across borders, then we would talk about renditions. I'd still have some problems with it, especially when they're meant to circumvent the regular extradition processes, but I agree that it's a regular procedure done by many different countries, and there's nothing illegal about them. But when we talk about extraordinary renditions, we are signifying that there's something different about this type of things. And the one thing that is very different is, one, yes, we seek assurances from countries that they won't torture them, but then we don't really follow through very carefully. And quite frankly, it seems to me at least questionable that very significant people with significant intelligence value are given over to countries under assurances that they won't be tortured, and then return to the United States with the intelligence as if we didn't know that they were going to be tortured, as if we didn't know that they were going to get that information from them in that manner. But more important than that is the question of clandestine detention centers and the fact that many of the people who are so extraordinarily rendered, if that's a verb, are mired in secrecy and in complete silence and denial even. That comes very close to what we in Latin America call disappearances. And if you, and this is where I go back to my more personal experience. I do completely agree that military establishments in Latin America took these things to the grotesque because they did it in such massive and systematic and widespread ways that it's just not comparable to anything that we could be talking about today. But I do want to submit that there is a slippery slope that didn't start with General Videla or General Pinochet. It started with civilian leaders not exercising their responsibilities and lending a blind eye to practices that they knew were going to happen because maybe they'll just go away after it happens and we'll be okay. The consequences for Latin America are not terrible. We have now democracy. We've had it in a very steady way for 25 years or so, or starting 25 years ago at least. Okay. But we have military establishments and police establishments, security forces, that have completely lost the confidence of the population that they are there to serve. And they are so mired in discredit that people don't wear their uniforms in the street. If we ask American soldiers and officers to do these kind of things, and if we let them do it more frequently and more assiduously in the future, this is the kind of scenario that we have to look for. And it's not fatal. It doesn't have to be that way. But it does create several problems, because even with the democracy that we now enjoy in Latin America, it's still very difficult, for example, to trust organizations like the police to deal with citizen insecurity, because just people don't trust them, so they don't cooperate with them, and therefore crime becomes a spiral where we don't have any effective way of dealing with it. But I want to use my last 2 minutes, I hope I still have, to deal with not so much with what are the standards, but what to do about it. And I think the first thing that we need to do is first hold these conversations and have them as frank exchanges as possible. But I think we need to move quickly to undoing some of the wrong that has happened. Some of these memos and internal documents have been withdrawn or disavowed by the administration, but I think there's a lot of cleanup to happen, and there's a lot of legislation that has to be changed back to what the more enlightened human rights policies of the United States have been for a long time. I also think that we need to remind ourselves that torture is a crime against humanity. When it's practiced on a widespread or systematic basis, it is a crime against humanity. So it is incumbent on the courts and the prosecutors of the nation to investigate, prosecute, and punish every single event of torture, and make sure that in that fashion, not only we give victims a right to justice, but we also ensure that these practices are not condoned, not tolerated. But I think it's very important also to deprive torture of its effects. The Wolf case in the United States that established the fruit of the poisonous tree doctrine is gradually making its way to international law, and it started in the United States. And I think that should be reestablished and practiced here as well. I think that basically brings me to whether these questions apply or don't apply because these things happen in territory other than the United States. And I come back to international human rights law. Under international law, the answer is very, very easy, because the treaties Thank you. The treaties say specifically that all of these human rights standards apply to everybody who is under the jurisdiction of the party to the treaty. And whether you're in the territory of the country or in another territory or anywhere, I just can't imagine of anybody being more under the jurisdiction of a country than when you are arrested by agents of the state of that particular country. So whether in domestic constitutional law you can make some distinctions as to where the event applies, under international law the question is the same. It doesn't matter whether you're being mistreated in New York, in California, in Guantanamo, in Bagram, or wherever, as long as the agents of the state who are conducting the mistreatment are part of the state apparatus of the United States is liable under international law. Thank you.
Thank you, Juan. Tom.
Thank you. Let me start by telling you what I'm not going to do. I'm not going to talk to you about morality. I'm not going to talk to you about ethics. And I'm not going to talk to you about the law. There are people on both panels much better placed to offer arguments on those subjects than I am. What I'm going to do is a slightly different pitch. I want you to understand where it's coming from first. I served for 6 years as a British Security Service officer. I worked primarily in the field of international counterterrorism. I worked for 4 years as an international war crimes investigator, serving at the ICTY. I served in the CPA, the Coalition Provisional Authority, as a British representative to the Iraq High Tribunal at the same time that the CJ TF7 memo was written that we saw earlier. In short, I'm an investigator. What I do for a living and what I like to do for a living is put bad guys in jail. I've also been blown up twice by terrorists. I do not like terrorists. I've spent a lot of my time trying to arrest them and try to put them in jail. I want to win the war on terror. So what I'm going to give you is a pitch on practical utility. I'm not going to talk to you about the rights or wrongs. I'm just going to tell you a story, and tell you a story from the early 1970s from Northern Ireland and the British experience combating terrorism with much the same techniques that we've heard talked about all morning. In the fall of 1971, if anybody can remember back that far, things were going terribly, terribly wrong in Northern Ireland. A whole 21 people had been killed in the first 8 months of the year. Shock and horror. The country was falling apart. Something must be done. Brian Faulkner, the Prime Minister of Northern Ireland, it had a Prime Minister back in those days, convinced the British government that the army had to intervene, and it had to intervene dramatically. What the army launched was something called Operation Demetrius. It was internment. It was a decision: we will not try and prosecute people, we will simply take the players off the map. We will knock on their doors, kick their doors in, and hold them for as long as it takes to regain control of the situation. So on August the 9th, 1971, the British Army launched this operation, and it detained about 342 IRA suspects around the province of Northern Ireland. Unfortunately, most of this operation was planned and conducted on the basis of out-of-date intelligence collected the last time the British military went up against the IRA, which was in the cross-border campaign of 1956 to 1963. So the information wasn't wildly current. The British Army deployed on the streets of Northern Ireland with anti-riot banners in Arabic, because the last time they'd been doing this stuff, they'd been in Aden. Again, not brilliantly culturally sensitive. Just after the operation started, the IRA held a press conference. Not, you might think, in Dublin, but in Belfast. The chief of the IRA's general staff at the time, a man by the name of Joe Cahill, met a whole bunch of journalists. Strangely, the British Army wasn't present. And mentioned that he was fascinated by what the army was doing and saw that they'd arrested 342 people. He reckoned about 30 of them were probably members of the IRA, which didn't bother him a whole hell of a lot because he was about to join the Provisional IRA. Again, a little embarrassing for the British authorities. Within 48 hours, the British have released about a third of the people they'd arrested. One of the gentlemen arrested was in his 90s. I love this story. He's released, he goes to the media and he just says, "I'm so glad the British still think I'm a threat." Unfortunately, this would be bad enough. The other thing the British did at the same time is they introduced a series of colonial interrogation techniques. We all love our euphemisms in this business. The British called it interrogation in depth rather than highly coercive interrogation, but it amounted to much the same thing. It was a type of interrogation that had been used moderately successfully in previous colonial insurgencies. Bit of a clue there. in places like Kenya and like Cyprus. The techniques involved, and these may stop me if you've heard them before, are called the 5 techniques. They include hooding. They're all pretty self-explanatory. Wall standing, subjectation to noise, relative deprivation of food and water, and sleep deprivation. So hooding, you stick a prisoner's head in a cloth bag, an opaque cloth bag, with no ventilation. You only take it off when he's being interrogated or he's back in his cell on his own. The prisoner would often be stripped naked to enhance his feelings of vulnerability. Wall standing consisted of forcing prisoners to stand balanced against a cell wall in the search position you see on TV cop shows for hours at a time. Incidentally, I wouldn't call a fetal position a stress position. I mean, the point of the exercise is to put stress on the muscles, create cramping. I mean, that's where the pain comes, and it's not simply about standing. It's about muscle spasms and being forced to hold a position as you have muscle spasms. It's not just 4 hours. It's not just 8 hours. One prisoner was held in a stress position in Northern Ireland for 43 hours and a half. There are at least 6 other instances of people being held in stress positions for 20 hours. You might also want to think, how do you keep somebody in a stress position? You don't persuade them to stand in it. You don't say, pretty please, stand there, I'll go on, stay, so you can do it for another hour. You hit them and you threaten them if they move out of the position. So when we talk about stress positions, bear in mind there has to be some coercive force to keep the person in that position. People don't really talk about that. Subjection to noise. Well, back in the day, we didn't have rap music, so the British Army used white noise, which is machinery, the hum of machinery. Doesn't sound terribly bad. A man by the name of Jim Old told Amnesty International that he was driven to the brink of insanity after 4 days being subjected to white noise and tried to smash his head, break his head open against the pipes in his cell to stop the noise. Food and water deprivation, we're essentially talking bread and water. Sleep deprivation, one of the oldest interrogation tricks in the book, often used in tandem with other methods. So again, it's not just sleep deprivation, it's sleep deprivation and then being put in a stress position or something like that. Detainees were usually subjected to this conditioning over the course of a week. We don't actually know who did this. There is a great deal of confusion as to whether or not it was the Royal Ulster Constabulary or the British Army or both. The names of the individuals involved in the interrogations have never been revealed, nor indeed has the unit responsible for these. But it's a reasonable assumption that it was probably both acting in concert. As always happens, a little bit of creativity crept in around the edges. Various other things happened. Detainees reported being forced to run over obstacle courses with smashed glass on the ground, so they cut themselves when they fell down. And perhaps the most serious of all, being taken up in a helicopter and being led to believe they were about to be thrown out. The helicopter was actually just hovering off the ground, but somebody would be thrown out of the helicopter, land on the ground, and everybody else would assume that he'd fallen to his death. So that's the sort of stuff that was going on. It didn't get wildly out of hand. It was stopped actually remarkably quickly. We don't know how many cases of people were subjected to this. We know in detail about 12 cases. There undoubtedly were more than that. But again, it was relatively minor in terms of its application over a prison or detainee population. Nevertheless, it had huge consequences. And that's what I want to talk to you about. Quite interesting. If we go back to the beginning, why did we do all this? 21 people dead in Northern Ireland in 8 months. It's the beginning of the end. Something must be done. After these methods were introduced, 147 people died in the last 4 months of 1971. 1972 was the most violent year of the Northern Ireland conflict. 467 people died. In 1970, there were 150 detonations of terrorist devices in Northern Ireland. In 1972, there were 1,382. So, did these methods actively help the British prevent insurgency in Northern Ireland? Yeah, you always have to be a little careful about cause and effect, but I don't think it's a huge intellectual leap to suggest that probably not is the answer to that question. There's other very significant thing, and I'm afraid I arrived a little late this morning, so I didn't hear all of the presentations in the first panel, but you also need to think about the impact it has on your allies. Now, when you think about the Northern Ireland conflict, you don't immediately think about the Irish government as being a natural ally of the British government. You would be wrong to jump to that conclusion, despite the fact that the Irish government has enormous sympathy. Indeed, in its constitution at the time, the constitution called for the reunification of the 6 counties with the rest of Ireland. The Irish government is not the natural friend of the IRA. The IRA does not recognise the Irish government. It sees it as an illegal government, the continuation of the side that won the Civil War. The IRA was on the side that lost the Civil War. So the Irish government and the IRA are not natural allies. During the Second World War, the IRA launched a terrorism campaign on the British mainland. The Irish government helped the British authorities stop that terrorist campaign and helped the British authorities arrest German Abwehr agents operating in the south of the country to try and build up IRA operations. During the cross-border campaign of 1956 to 1963, the Irish government interned people associated with the IRA just like the British government did. Internment was used both sides of the border. In fact, it's an Irish idea. It was adopted in the south before it was adopted in the north. IRA prisoners rioted in Dublin jails, and the Irish government shot them. Used live ammunition on IRA rioters in prison, in Montcalm prison. So this is a country, this is a government that you would think would have some natural sympathy with the British government confronting IRA terrorism. Unfortunately, once you start torturing Irish Catholics, it's very difficult for a government in Dublin to have much sympathy with your position. So what happens in 1971 is the British alienate their most important security partner, the one country, the one government that can prevent the IRA retreating to safe areas, training its people in locations where the British military can't reach it, storing their weapons across the border where the British Army can't get to them. We lost all of that. It gets worse. You're probably aware of Bloody Sunday. We had troops on the street. They open fire in Londonderry. They kill Catholic demonstrators. A mob in Dublin burnt down the British embassy in response to Bloody Sunday. Again, you could get a fairly graphic illustration of by how much we had lost the sympathy of the Irish public. So without the public and the government on our side in the south, there was no way we were going to get any sort of security cooperation from the Irish. What they did instead was take us to the European Court of Human Rights. That may not sound terrible in the United States, but let me tell you, at that point, no country had taken another country to the European Court of Human Rights. It's the first time it ever happened. They took us to the European Court of Human Rights primarily because of the coercive interrogation techniques. The European Commission, in those days, it was a bifurcated process. There was a commission that then referred cases to the court. The commission took these techniques and described them as torture. The court looked at the techniques and was a little bit more sympathetic and described them as cruel and inhuman, and degrading. Stopped short of using the word torture, but still made it a breach of the European Convention on Human Rights and ordered the British government to pay compensation to the people that it had actually abused. Again, not a brilliant situation when the British government is giving money to the people it believes are members of a terrorist organisation trying to overthrow it. And it's quite a lot of money. You know, you're talking £40,000, £50,000, $100,000 effectively, that's going straight into the IRA's coffers. The British government did respond by ending internment. It did respond by ending interrogation in depth. The British Attorney General, who was summoned in front of the European Court of Human Rights, made a commitment that we would never use any of the 5 techniques again. Briefly in Basra in 2003, the British Army started hooding people in the American practice during security sweeps, and it took about 3 weeks before the House of Commons had somebody denouncing the practice and it was discontinued. So we take that very seriously in the United Kingdom now. At the time, it's worth noting, the British government argued that there was some practical utility to this. They argued that they had actually been able to identify 800 active members of the IRA. We believe that the active number of people in the IRA has never really been much more than 200 to 300. So that's a somewhat implausible claim. And they claimed about, 1,600 different criminal incidents. They had obtained information on that. Now, a criminal incident can be almost anything from obstructing the police in their inquiries to something more serious. When people throw away figures and statistics like that, you want to think about how minor they can be, because if they really had significant events to tell you about, they would have told you about them. So there was this argument that was put forward. It's useful. It had value. Unfortunately, those people involved in the process at the time, the most significant was a Secret Intelligence Service officer by the name of Frank Steele, who was SIS's liaison to the counter-terrorist effort in Northern Ireland, has told a journalist by the name of Peter Taylor that there was no practical utility and he could not remember any actionable intelligence resulting from the use of these techniques. You know, perhaps the truth lays somewhere in between. But I'll tell you something as a professional. You have about 48 hours when you catch someone to have actionable intelligence, and after that, it's all dead and gone. So having somebody for 3 or 4 years in Guantanamo has no practical utility as an intelligence measure, but it does have a massive impact on a country's reputation around the world, its ability to build partnerships with governments that can help it defeat terrorist organizations. And it has a huge impact on the population itself, whose cooperation and assistance you need to defeat terrorists. So there's my pitch. It doesn't work. It's not practical. You should avoid it. Get good interrogators who can actually build rapport with their suspects and get information out of them. That's how you break terrorist rings. And that's how professionals do it. The people who use violence in interrogations are poor interrogators who don't have much skill, who get frustrated and think it works. It's asinine, is the bottom line. You want to build a rapport with somebody. You want them to help you. When you interrogate somebody, let me tell you how a coercive interrogation goes. You smack someone, you demand the answer to the question. He says yes or no. You smack him again, demand the answer to the question. He says yes or no. You have to know the right questions to ask before that can even be vaguely useful. Bear in mind, in the intelligence game, you don't have 100% of the picture. You have a small bit of the picture. Frequently, the questions you go into an interview with are not the right questions to be asking. If you build a rapport, the guy says to you, how do you keep asking about X? Why do you keep asking about X? It's Z that you want to be asking about. The X isn't anybody. That's what happens when you build a rapport. If you're smacking the guy with a baseball bat saying, tell me about X, tell me about X, tell me about X, you're never going to get to Z. And that's why good interrogators build a rapport. It's a great book, Looming Tower. I'm sure you've all heard of it, by Lawrence Wright. Check out the interview done by the FBI's Arabic-speaking investigator, special agent in Yemen, just after 9/11. That's how a good interrogator works. He builds a rapport, he develops sympathy with his suspect, and he persuades the suspect to cooperate. Does it work every time? Absolutely not. It works a small proportion of the time. But you know what? The intelligence you get when you do it that way is gold dust, and it's an awful lot better than anything I'm ever aware of coming out of coercive interrogation.
Thank you. As I mentioned when we opened this panel, I'd like to invite the members of the first panel, William Taft, David Rivkin, Seth, if they'd like to spend a few minutes responding to the comments that have been made. I see David standing up. Is Will still here? There you go. Whoever has the microphone, if you could pass it around here to David in this corner.
Thank you very much for giving me the opportunity. I wish I had more time because I would have liked to concentrate more on the remarks of our British colleague. Tom, can't see very well from where I am. A couple of things. You make a persuasive case, and God knows I'm not an expert on Northern Ireland. The truth probably, as you say, is in between. I've had British colleagues tell me that the coercive interrogation techniques were indeed far more fruitful and really helped to develop a pretty good intelligence picture that you don't need to do it later, but who knows? It's probably somewhere in between. One pedantic observation, but it's an important one. I've read very carefully the relevant opinion of European Court of Human Rights. They didn't talk about individual techniques being illegal. They talked about all the techniques used together. So even such a progressive body as European Court of Human Rights never said that hooting as such is impermissible. But let me say this. I mean, I'm curious, I'm not being rhetorical. Do you not perceive a fundamental difference between the ability to build a rapport with an IRA sympathizer, products of a fairly common Anglo-Saxon, Scottish culture, whose grievances against Britain, while real, and when I get into Irish history, are nevertheless limited, who are not interested in exterminating Britain, who are not interested in converting Britain. Do you not see fundamental differences between that situation or when you're interrogating some communist rebel or guerrilla in Latin America, and a situation we're facing now where the ideological gap between the people who are doing the interrogating and the people who are being interrogated is so vast, is so enormous. And I'm not actually saying it to demean them. I think they're horrible people, but let's give them their due. People who are willing to fly planes into buildings and die for their cause. Extremely unlikely to be much persuaded by some Westerner. Even if you speak Arabic, even if you understand the culture, very unlikely, with all due respect, to be able to build rapport with these chaps. Enormously unlikely. And in some sense, the colonial experience that Britain had, those things did work well in the colonial context precisely because it was not easy to build the rapport with people in far-flung portions of empire. So do you not think that the calculus is fundamentally different in that case? Now, as to, very briefly, as to the cost. Of course there's a huge cost. And in some sense, at this point in time, maybe we shouldn't use any stressful techniques because the cost has become so high. But why has the cost become so high? Is it inherently the problem of those techniques? Or is it frankly the fault of the people who drove the debate, who polarized the debate, who postured it in such a way that it's all horrible and inherently evil and we're in a slippery slope and is one step away from modest hooting to pulling out fingernails? It's like renditions. I've written that my renditions are illegal. We probably shouldn't do them anymore because we're paying too high of a price. And we're probably at a stage where we shouldn't be doing any coercive interrogations because we're paying too high of a price. But I honestly feel that it's not because this is inherently so. It's because various critics, and not to point fingers at anybody, I don't know how much of folks in this panel contributed to it, but most critics have made it impossible to have a rational debate. And I despair because I cannot get anybody to answer a straightforward question. Why a civilized society that permits modest levels of coercion of prisoners in civilian penitentiaries and recruits cannot morally stomach doing at least that much to the unlawful combatants that we capture? But nobody wants to talk about it. At least it would be more honest if we just say, let's get rid of coercion entirely. We're too civilized in the 21st century. There should be no coercion. No yelling at school children. Parents should not slap kids, and there are states that ban that actually in this country. Prisoners should be treated with utmost courtesy. So if a guard should say, "Sir, would you please march to your solitary confinement?" There should be no drill sergeants. Let's do that across the board. At least then we would de-coercicize the society. But that's not what we're doing. And I don't understand why that makes any sense. Thank you.
Sure. Is William Taft still here?
Sure. Yes, I am. I really don't. I would just have two comments on the presentations. One relates to the situation in Iraq, and I think a very unfortunate thing that it was not as clear as it should be that in Iraq that conflict was governed by the Geneva Conventions. And there was no argument about this. The conduct of our forces there was governed by the conventions because Iraq was a high contracting party to the conventions. And all of the things that occurred there, which were not consistent with the conventions, were in violation of our obligations under them. And that was the policy. Sometimes there were certainly, I think, problems of migration. There were of practices that were approved in situations to which it had been determined, whether rightly or not, that the Geneva Conventions did not apply to Iraq, and that was something that should not have happened because it was clear that the Geneva Conventions did apply. Second point has to do with the subject of really the accountability of who is in detention, and Mr. Mendez brought it to my mind at least by mentioning the disappearances policies or practices in Latin America. I think one of the things that we certainly have made that has been regrettable and should not have been done was the failure to notify a third party of the fact that certain people were in detention with us. As soon as you start down the track of not acknowledging that people are in your custody, you begin to lose the accountability for what happens to them. The temptations become extremely strong. if something goes wrong for that person, say they even die of natural causes, to just not bother, to say that they were in your custody at the time and to just let it go. You also set, obviously, a very bad precedent for your own troops who are likely, in many instances, to be captured, whether they're pilots who've been shot down or things of that sort. And it's the easiest thing in the world for another government not to acknowledge that it has somebody in detention, and it's not a practice that we want to start down that road. And so it did seem to me, and I was very glad when the president acknowledged that all of the people, the people when they were brought to Guantanamo in last September, that those were the only additional people that we had in custody who were not had not been identified so far, and it seemed to me that that was a step in the right direction. Whether while he did not, the administration did not commit to acknowledging all people in the future that it might have in detention, and also did not account for people who had been in detention and were no longer in detention, have been released to one place or another. It was a step in the right direction, and I think something that we really need to worry about the implications of holding people without any acknowledgement as to who they are, and it is the way to disappearances. Thank you.
Okay. Seth, if you're still here, I'd like to give you equal time. He's taken off. Okay, I welcome comments, questions from the audience. As before, please identify yourself.
Is it possible to get Tom to respond?
Oh, sure. Tom?
Sure.
Okay.
Well, I guess I wrote a quick little list here. I point out we lost our colonies, so it wasn't a wildly successful tactic. You asked a really good question about cultural differences. I don't think it does make a difference. You know, I talk from the perspective, I've interviewed people in Iraq, I've interviewed people in Bosnia, I've interviewed people in Chad. I've done human rights training in Nepal with the Nepalese, frontline troops and law enforcement. In Lebanon, with members, bizarrely, of Hezbollah for the U.S. government, where we weren't allowed to refer to Hezbollah as a terrorist organization. Oh, 2005, what a lovely time that was. Very strange experience. I've done training in Sri Lanka. I've done training in Thailand. And one thing that has struck me whenever you're talking to soldiers, law enforcement, or perpetrators or victims, is that there are some commonalities in the human experience, whether you're talking to somebody in a shebang in a refugee camp in Chad, or whether you're talking to somebody in a fancy pad in Mansour.